Thank you, Mr. Speaker. Would the distinguished chairman of the Judiciary yield for a few questions?
Gentleman, continue to yield. Gentleman yields.
Certainly.
Thank you, Mr. Chairman. I will be brief, and I appreciate your patience during all these questions. As you've already stated and has been elaborated by several delegates, to the best of our knowledge, we'd be the first state to have taken this route to reschedule this to a Class 4 drug. Would that be correct?
Yes.
Would it also be fair to state that assuming that the DEA and the FDA don't like this tactic, that this could spawn a significant lawsuit between the state of West Virginia and the federal government?
I think that's a possibility. I can't really certify that's going to happen.
Gentleman makes a point. I think he's asking about the...
Mr. Speaker, I'd say that any bill, without regard to what we do in this chamber, any bill we pass is apt to be subject to legal review, and that's where I'm going with this.
Well, to the gentleman, I understand your objection, but we have talked a great deal today about the interaction between the federal law and the state law, and I think the gentleman's question goes to that interaction. And again, I think it would be up to any other member to argue if they disagree with the answer, but I do think it's relevant to what we're talking about.
Thank you, Mr. Speaker. Thank you for consideration. Again, Mr. Chairman, if this, so you do see an avenue that the FDA and the DEA could come back against this law in the state of West Virginia?
I can't speculate what the federal government would do, but it's going to create some serious inconsistencies, not only in enforcement, but in the definitional provisions. Because we haven't done any real studies, we can't, for instance, determine if it would affect federal funding of any particular program. It could. An FDA-sponsored program where we're inconsistent in the application of our law from their law possibly could affect any funding that might come from the FDA, the DEA. Those are all, as I said, we're sowing the seeds of uncertainty. A lot of things could happen. All those things would need to be studied.
No, patients can't sue because it's federally illegal.
It certainly could. I think the federal government, they have a lot of conditions on any type of funding. Could also have some certification or licensing issues because there's inconsistency between our law and federal law. It's just hard to predict all the consequences.
Thank you, and you did answer my second question there, that you could see an avenue where this would affect funding. Now, if you don't care, I just one or two other small questions. If such a legal avenue was pursued by the federal government against the state of West Virginia, that could be fairly protracted in your opinion?
Possibly, yes. Possibly.
Okay. And costly?
Litigation is costly, yes.
Okay. And also, and when you studied how the other states have implemented medical marijuana, there is absolutely no implementation features in this change in scheduling. Would that be correct?
Yes, that is.
So we would have to go through rulemaking and the Board of Pharmacy, assuming that they would go along with this. If they didn't, the effect of what we would do today would perhaps even hurt the cause of medical marijuana. Could that be one of the scenarios if we got embroiled in a federal lawsuit?
Possibly, but I mean, that's one reason you'd like to go through our process and ask the Board of Pharmacy, for instance, or the Board of Health, what sort of consequences we might have so we can anticipate those, what sort of problems there might be if we do something different than what the federal government suggests we do. But we don't have any of that information, so.
Okay, well, thank you. You've answered my questions. Thank you, Mr. Chairman, and thank you, Mr. Speaker.